Good morning, everybody. Welcome. We're just going to give it a second here so that everybody can file in, as it were, and get settled. Going to get to spend an hour and a half with each other. Hopefully you have a good cup of joe or something. It's probably not politically correct anymore, is it?
Cup of joe?
Let's stick to coffee.
Just in case.
I think Eli's going to cover that. It's in one of the future slides here today.
Not everyone's cup of tea.
There you go.
All right, well, we'll go ahead and start. Good morning, everybody, and welcome to the 2022 Labor Law Update, sponsored by the Alameda County Workforce Development Board. My name is Tara Brennan, and I'm the Events Manager here at CEA. Before we start today's webinar, I just want to go over a couple of details with you. Your audio is muted. If you have any questions pertaining to this webinar, please go ahead and put those in the Q&A box down at the bottom of your screen. That's where our presenters will be monitoring for any questions, and they'll be able to help you out there. If you have any technical difficulties, or if for whatever reason you did not receive the handouts for this presentation, go ahead and put your email address into the chat box. That's where I will be, and I will be able to help you out there. There is a quick 30-second survey at the end of this webinar. Please do take that for us. It really helps us out. We're here to help out with our webinars, and your information and feedback is prominent in that. Also, just a reminder that the recording of this webinar will be available on the Alameda Workforce Development Board's website later on this week. So without further ado, I'd like to go ahead and introduce Carmelo San Mamez. He is the Senior Strategic Partnership Coordinator at the Alameda County Workforce Development Board. Carmelo, it's all yours.
Thank you. Good morning, everyone. Thanks for coming today. Yeah, we are happy to host this with our partners, California Employers Association. You guys are in great hands. These are subject matter experts, and we're glad to have this service made available to all our local businesses and our HR professionals. We get a lot out of this one, and we're glad you guys are here. And so we look forward to hosting this one and future ones also. So thanks for coming.
Awesome, Carmelo. Thank you. Well, we love our partnership with you guys as well. So now, without further ado, again, I'm going to present our two presenters. That's Astrid Servin and Eli Nunez. Both are our HR directors here at CEA. So it's all yours, guys.
Thank you, Tara. I'll go ahead and jump in first. But first, I want to remind everybody participating, remember the hotline number for our Alameda County employers, 888-202-5668. If you have any questions about any HR related matter, COVID, anything like that, give us a call. We'd love to help you. We really enjoy this partnership with Alameda County, and we're here to help. A little bit more about us. We are California Employers Association. And our goal here is to provide employers in California with peace of mind. We provide, as you can see, exceptional human resources compliance solutions, training, recruiting services, webinars such as this. Any phone call with questions you want to make to us, go ahead and call in. I mean, there's no limit to how many times you call. You don't get one call a week, one call a month, or what have you. If you have 5 questions in the day, 5 separate questions, give us 5 separate calls. We'd love to help. Anything besides that, we're also a membership service, so we offer some other services to our members. If you're interested, poke around our website and take a look. Having said that, though, one thing we are not lawyers. We do have some people with legal expertise on our team, but we are not your lawyer, so to speak. So this presentation should be taken as educational presentation. We're going to go over some of the changes, some of the new laws or things affecting the workplace that are coming into play in 2022, but it should not be taken as legal advice. If you have any questions of a legal nature, please consult your personal or your business attorney, your business counsel, anybody that could give you that advice. It is not something that we do, of course. So let's jump right into it. Some of the topics we'll be covering today. I will take the first half and we'll talk about wage and hour updates. We'll talk about some changes to Cfra or California Family Rights Act, your posters, record retention, and Cal Savers. Those are all things that there's new legislation or new regulations around. Then I'm going to hand it off to Astrid for coverage on our safety and everybody's favorite topic, COVID-19. And we'll wrap up with some new and unique laws that have been enacted that affect specific industries or specific workplaces. So we'll talk about those a little bit in case it's something that affects you as well. As always, you have any questions, feel free to type into the Q&A. We'll monitor them throughout. We'll jump right into it. The first topic we're going to talk about is wage and hour updates. And as many of you recall, a few years back when Governor Jerry Brown was running things here in California, he set the goal of having a living wage for all Californians, which was defined as $15 per hour. So the goal was to gradually move up to that $15 per hour range. And we're getting there. We're actually 1 year away from being fully there. So as of this year, the new minimum wage starting January 1st for large employers, which is defined as those having 26 or more employees, is $15 an hour. With anybody that has 25 or less employees, that's only $14 an hour still. So you still have 1 more year to hit that $15 mark if you're one of those small employers. Something that comes up, and the thing to remember is what happens if you're right in the cusp. You're right at that 25 to 26 range. You gain employees throughout the year, then you drop below that 25 range. What should you do? And the recommendation from the Labor Commissioner on this is that you should pay the higher minimum wage for whatever pay period that change takes place. So, for example, if in the middle of the pay period you go from 25 employees to 26, then you're going to want to jump up to the higher wage for that pay period, just to stay in compliance. Now, if you go the other way, something to keep in mind is, do you want to take that extra $1 an hour back, or take it away if you drop down below that 26 employee mark? And that's decisions up to you. I mean, as long as you do it for the pay period, you're fine. But something to keep in mind, if your headcount is going to fluctuate throughout the year, do you really want to fluctuate back and forth with the wages? And the other thing to keep in mind too is what's going to be the morale. How's that going to affect your workforce, right? As you know, when you give something to employees, it's always a good thing. When you try to take something back, it's always difficult. So a lot of things to consider, but the thing to keep in mind is, as soon as your headcount switches to one of those categories, especially if you go up to that 26 or more, you should change that minimum wage pay rate for the entire pay period. Now, on top of the state minimum wage, we also had some increases in local municipalities here. And, being in Alameda, you guys know that the Bay Area has a lot of different areas. And usually the king of the hill as far as minimum wage in California has been, where are we at here? Emeryville is usually right at the top. They have a minimum wage right now of $17.13 an hour, if I'm not mistaken, with an increase scheduled for July 1st as well. So throughout California, there's 27 different minimum wage increases that took place on January 1st. West Hollywood jumped into the mix this year for the first time. Initially, there was a change made for any hospitality or hotel workers, but now it's, it looks like it could affect other places. So keep in mind, always be aware what municipality you're in and what your minimum wage is. Something else that comes into play with this too is if you have any remote workers who are 100% remote or who work out of their homes, the minimum wage that applies for them is based on where they live. So one thing we ran into in the past couple of years is that some employees moved around without telling their employers, moved to other, higher paying municipalities, that sort of thing. And when the employers found out, they realized that they weren't paying them correctly. So always keep track of your employees, of course. I know in HR, we always like to audit at least once or twice a year to make sure everybody's information is correct. So make sure you're doing that so you know where everybody's at. And so you're complying with all local minimum wage, sick time regulations, all those types of fun things. And of course, we've been talking about the hourly minimum wage, but this also has an effect on exempt employees or salaried employees. And under California law, in order to be exempt, you have to meet 2 tests. One is a duty test, which is, it could be for administrative, management, computer professional, that sort of thing. But also the other one is also for minimum wage. So under California law, in order to maintain your exemption, you have to earn at least twice the yearly minimum wage. In other words, you multiply the hourly minimum wage times 2,080 hours and multiply that by 2. That will give you your yearly minimum wage for salaried employees. Now, this is important to discuss. I mean, in many areas, people such as supervisors or other managerial employees are seen as exempt, but sometimes they fall right in that limit. They're right in the cusp. They're right around the high 50 to low 60 range. So if you have exempt employees and you're a large employer that are below that $62,400 threshold, you have to do an increase in order for them to maintain their exemption. You can always make them non-exempt employees, but then you have to consider other things such as overtime, lunch breaks, lunch and meals, regular breaks, that sort of thing. So, as well as having to go back to track their hours. So keep in mind, always audit those your exempt employee wages, not just to make sure you're competitive, but also to make sure that they are meeting the minimum requirements for the state. Along the same lines too, when we're talking about exempt employees, a couple of categories that saw some changes as well this year. We have for physicians and surgeons, the hourly minimum wage increase from $86.49 to $91.07. And then for computer software professionals, minimum wage increased as well. And you can see the calculation there on the screen based on hourly, monthly, and annual salary rates. Quite a big jump, when you look at the annual rates there. I mean, it's almost $6,000 jump there. So, takes a bite out of the budget. And the way that the state determines what these minimum wages should be was they look at the California Consumer Price Index for urban wage earners and clerical workers. In other words, they try to kind of maintain the cost of living or maintain that increase along with that. So if that cost of living goes up, obviously they try to adjust those wages somewhat accordingly. Being from Alameda, that wages and cost of living can be fairly high, and big changes make a difference over there. So that's kind of what went into that was the thoughts that went into making those changes for these two exemptions there. So some things to keep in mind when it comes to wages, paying your employees, or what we call proper payment deal breakers, is you want to make sure you review all your local minimum wage requirements, and that's where you have workers. As I mentioned, there's a lot of municipalities that have their own regulations, not just for wages, but for sick time or other things like that. So make sure that you're, reviewing all the ones that affect you and you're staying compliant with that. Something that we always have questions about here at CEA is vacation policies. And in California is what's called a no use it or lose it state. In other words, any unused vacation cannot be taken away at the end of the year. The state of California sees vacation as compensation or wage, an earned wage, so it cannot be taken away. It must be paid out at termination, paid out at the end of the year, or rolled over. Now, you can't put what they call a reasonable cap on accruals, and the state of California sees a reasonable cap as a maximum of 1.5 times the yearly earning for it. So just remember, when it comes to vacation, it's a no use it or lose it. The same applies if you combine your vacation and sick time into a single PTO policy. Basically, all the protections of vacation apply to that PTO policy. So it can't be use it or lose it, must be paid out upon separation or termination, all those good things. Working off the clock, obviously for your non-exempt employees, all work should be done on the clock. And I mean, there's a lot of trouble that could be had, not just for employees, but for employers for working off the clock. So, if you have a location where employees have to don or doff specific gear, safety gear, that sort of thing, to perform their job activities, that should be done on the clock. And more with what we're dealing with nowadays, if you're doing pre-work or pre-shift health checks, we're checking temperatures, having to fill out a questionnaire about Coba, that sort of thing, those activities should probably be done on the clock as well. So, some other examples are if employees have to lock up the store, shut things down and everything, make sure those are all activities they're being compensated for. And if you give your non-exempt employees, say, a company phone or things like that, and you're calling them after hours, make sure that time is compensated as well. Finally, if you are in the industry or in the business where there's tips involved and you pool the tips to divvy them out for everybody, make sure that owners, managers, and supervisors do not participate in that tip pooling program. That tip pooling is only for employees that participate or that are involved in it. but not for anybody from the management or ownership team. But there's a lot of laws, there's some laws in California that regulate that, so make sure that that's going on. And the reason that's important is because another one of the changes that took place was California increased the penalties for wage theft. So, and that's especially intentional wage theft. So if you see the definition here for intentional, we have knowledge that the wages, gratuities, benefits, or other compensation is due to the employee under the law. In other words, if the employer or management knowingly denied or did not pay out the right compensation, benefits, gratuities or tips to the employee, that's going to fall under this category. And it's now categorized as grand theft and subject to the penal code. So if we look at some of the trouble you get into for that, the state's going to look at what was the harm done. Was it done to the employer or to a group? And there's two categories they could look at. If one employee was affected to the tune of $950 or more in a year, and that includes employees or independent contractors, or if a group of employees was affected to the tune of $2,350 over the course of a year. And that's for two or more employees, independent contractors, et cetera. So if you're in the business that involves tips, that sort of thing, you know that kind of money can add up fairly quickly. So that's why it's so important to make sure that, if you have a tip pooling program or any other thing, make sure you're paying your employees correctly and only the right people are participating in it. Now there is, I don't know if we call it a carve out, but maybe a defense for employers. This does not include good faith mistakes. I mean, we know mistakes happen. Sometimes, we don't report something because we don't see it or we don't find out about it till later. So good faith mistakes could be something that'll help employers in this instance. But the most important thing is just make sure when it comes to paying employees, make sure that you are checking it twice at least. Some of the consequences that can come from this wage theft, of course, depending on the court and depending on the amount, it could be punishable as either a misdemeanor or a felony. And as you know, even the misdemeanor can carry some jail time, but once you get up to the category where it's a felony, you could be looking at imprisonment in county jail for 16 months or up to 2 or 3 years. Obviously depends on the circumstance, the amount, that sort of thing. So it all comes down to, there is greater consequences now than there were in years past, where maybe you just have to pay back the back wages or the back fees, that sort of thing. Now there could be some jail time involved as well. So what can employers do to protect themselves in these instances? I mean, it seems that there's a lot of traps, a lot of pitfalls for us to fall into. So one thing we always tell our members and anybody that calls is your frontline supervisors are going to be your best defense in this instance, right? Especially if they're the ones that are helping you track attendance, entering hours, maybe helping to report the tips, that sort of thing. Make sure that your frontline supervisors are, up to speed on what they need to be. So this includes making sure you have proper procedures in place, whether it's for attendance, whether it's for payment, whether it's for tip pooling. Make sure that you have those procedures in place and everybody's properly trained on them. Take a look at your policies. We like to tell everybody, we talk to all our members, make sure reviewing your policies at least once a year, everything from handbook all the way down, because obviously there's a lot of changes that take place and you want to stay up to date with them, right? I mean, when it comes to things like Coba, things are changing on a weekly, if not hourly basis sometimes. So it's very important to keep up to date with them. Don't just write that policy book, that handbook, put it up on the shelf and let it gather dust. These things are living documents that have to be updated periodically. And finally, if you work with an external payroll provider, make sure you audit them. I mean, just because you assume that it's their business to do payroll doesn't mean they're doing it correctly all the time, right? A lot of them may be based out of state. As we know, California is quite its own beast. So make sure that you're partnering with them, look at their procedures, asking questions. Don't just always assume that they're the experts, right? You want to ask questions. You want to get clarification on things. And if you have any doubt, reach out to them to make sure that they're keeping you compliant. Moving along to another topic or another pain point for California employers, we have dealing with independent contractors. And if you've been to any of our labor law updates in the past, you've heard us talk about the ABC test. And this is basically how to determine, or how the state determines if someone's an independent contractor or an employee. Now, keep in mind that the state basically presumes that all workers are your employees unless they meet these 3 qualifications, right, for being independent contractors. And these are that they're free from control and direction of the hirer. In other words, that you. They perform work that is outside the usual course of the hiring entity's business, and that they're customarily engaged in the trade, occupation, or business in the same nature as the work performed. So those last two, in other words, if you are, say, for instance, an accounting firm and you hire an independent contractor to do accounting work for you that's similar to what you're doing every day, chances are they're an employee, not an independent contractor. As far as C goes, if you hire somebody, if you're a carpentry business and you hire an accountant to come in and do carpentry for you, they're not engaged in the same trade as their business or in the same nature as their business. So, you want to make sure if you're hiring independent contractors, you're hiring them to do the work that they do that they're hired for, right? You can see it on the bottom here. Penalties can quickly add up. Each violation can range anywhere from $5,000 to $15,000. If there's a pattern, or if the state establishes that there's a pattern and practice of these violations. In other words, if they determine that you're doing this on a regular basis, those penalties multiply exponentially. So, make sure when you're contracting somebody from outside of your business as an independent contractor, keep this ABC test in mind. Make sure that, they are a true independent contractor and not just additional hourly help for you. And as always, we talk about the ABC test, but things, as you have come to expect, are not always as clear as it could be, and there's always exceptions. So there's certain workers that the state has carved out some exceptions for, such as attorneys, architects, engineers, travel agents, physicians. You can see them all on this page here. And there's also for certain business exceptions as well. So if you do business to business, in other words, if your company hires another company to do work for you, that could be an exception there. And then if you're involved in the construction industry, anybody that's done that at all knows that there's always contractors, subcontractors, a lot of hiring of outside firms or outside professionals to do work for you. So usually in order to qualify, you have to have a separate location and meet other criteria, such as signing a specific contract for a scope of work, that sort of thing. So, usually if you're involved in the construction business, you're pretty familiar with it. So, right. A few clarifications that also came to play this year when it comes to independent contractors. So a lot of the times these exceptions, as I mentioned on the previous page, they have an expiration date to them. For example, newspaper carriers are set to expire this year, or the exception for them, et cetera. So licensed manicurists, that sort of thing. So with new legislation that passed, they basically extended that expiration period until January 1st of 2025. So if you have any independent contractors, if you're in the business where you have newspaper carriers, construction, truck and subcontractors, that sort of thing, you don't have to roll them over as employees just yet. If they are true contractors, you have until January 1st, 2025. There was also clarification on a few other categories, such as data aggregator and insurance industry, claims adjusters, that sort of thing. So, basically not all bad news. Sometimes the state does go in and do some extensions for us or some clarifications. And that's what AB 1506 and 1561 did for us this year. Something that always seems to change year after year, every couple of years, is the mileage reimbursement. And this is no changes here. Actually, the IRS, the federal government increased our mileage reimbursement up a little bit this year. It's up to 58.5 cents per mile when you drive for business use. So as any of us know that, travel around the state, it was nice to see that increase in some instances because of the price of gas and other costs going up, right? Not such good news for business owners, but sometimes good news for the person doing the traveling. Something to keep in mind too is, many times we're asked, well, can I pay less than that? I don't think that's a true cost. I think that people are turning a profit for that. And the bottom line is, if you decide to pay less than the IRS rate, then the burden of proof falls on you to prove why you're paying less. In other words, you have to, show your work or show the math as to why you think that the true rate is less than 58.5 cents per mile. And sometimes it's the opposite. Sometimes employees come up and say, hey, you know what, 58.5 cents per mile is not enough to cover my costs. I'm wearing out my tires. I had a blowout. You should pay me more than that per mile. In that case, if they're asking for more than the IRS minimum rate, then the burden of proof is on them to prove that the cost is truly higher than what the federal government established. So let's talk about some takeaways in this wage and hour category. The first thing is, yeah, I mentioned that a couple of times, make sure you're keeping up with your county and city minimum wage laws, especially for if you have remote workers, right? You know, I mentioned there's quite a few throughout the state. So if you have workers in Southern California, if you have workers scattered throughout the Bay, make sure you know exactly where they are and take a look at those laws to make sure you're meeting all the requirements there. Make increases where and when necessary. This is not just from an industry standard, right? When we all like to stay competitive, especially in this atmosphere where there's a lot of movement, a lot of opportunities. People are trying to retain their good performers, but also with that minimum wage increase. As I mentioned, if you have anybody that's exempted, that's right around that $60,000 a year range, make sure that you're increasing that so they maintain their exemption as well. Not just the salary, but make sure that those exempt employees are meeting that duty test as well, right? There's a lot of guidelines on that. We provide worksheets to our members where they can analyze the positions to make sure that they are truly an exempt category employee. And miscategorization of employees can lead to a lot of fines from the state. So just make sure that your exempt employees and your independent contractors are properly classified. Doesn't hurt to take a look at them every year. Take a look at those job descriptions, especially for the exempt employees. Make sure they're meeting all the requirements. We do provide a wage and hour checklist for our CEA members. That's just kind of something to make sure you check. I mentioned make sure you check your policies every year, but also make sure you're checking all your wage and hour issues just to make sure that you're staying compliant. And finally, payroll audits. Make sure not only that your salary employees don't meet the test, but make sure that if you have an outside payroll provider, that they are staying up to date, they're providing the service you need, and they're keeping you compliant as well. So if there's one thing that'll raise people's tempers and get you in trouble with your employees, it is not paying them correctly. So make sure you're auditing that payroll every year, everyone's being paid correctly, and your payroll service provider is doing the right thing for you. We'll jump into our next section, which includes the CFRA, the California Family Rights Act. A lot of people call it by different names: CFRA, 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 whatever it is. Just that's California Family Rights Act is what it stands for. Some changes to your posters, record retention, and then we'll talk a little bit about Cal Savers as well, because there's some things we have to do, especially if you're a smaller employer. There's some deadlines for you this year. So, jumping to CFRA, a lot of times we describe this as the California version of the FMLA, or Family Medical Leave Act, right? And for many years, the two are basically mirrored each other. So basically, you could have one policy that covered both things. Well, in the past couple of years, there's been enough changes made to CFRA and enough differentiation where it should have its own standalone policy, its own standalone program. Ultimately, what the CFRA does is it provides your employees or any qualifying employees with up to 12 weeks of unpaid leave with benefits within a specified 12-month period. Now, as of January 1st, 2021, that's January 1st of last year, a big change that took place was that covered employers were the ones that had 5 or more employees. It used to have quite a bit more. I believe it was 50 or more. So in order for the CFRA to fall, or for you to fall under CFRA coverage. But as of January 1st of last year, if you have 5 or more employees, guess what? CFRA applies to you as well. And in order for an employer to be eligible, they have to have worked for you for 12 months and a total of 1,250 hours in the previous 12 months. So as I mentioned, there's a lot between these changes. It's enough to where employers need to have a standalone CFRA policy. It can't just be combined with FMLA anymore. It's got its own poster and its own mandatory form. So it's not just something where you can just add that, FMLA/CFRA anymore. The CFRA is its own entity for all intents and purposes. And even though many times it could run concurrently with FMLA, there's some circumstances where it runs separately or has to run separately. We'll talk about that here in a bit. This table gives us a good overview of the changes that have taken place. As I mentioned, as of January 1st of last year, if you're an employer with 5 or more employees, CFRA applies to you as long as those employees have worked for you for 12 months on a total of 1,250 hours. Now, as far as reason for leave, One of the changes that just took place in 2022 was they added a new eligible reason to take that leave. As you know, I mean, you can take it for adult children, children of registered domestic partners, grandparents, grandchildren, siblings, spouses, that sort of thing. But as of January 1st of this year, a parent-in-law is also an eligible family member to take that CFRA leave for. So, a couple changes, and as I mentioned, just enough to have to go back, and even if you got a separate standalone CFRA policy, got to go back and update it now. So, reinstatement rights are guaranteed. They got rid of the key employee exception as of last year. So it used to be where if you were a key employee, you wouldn't be guaranteed your position because of that leave. That has been taken away now. And another pretty relatively drastic change is if you have two parents working for you and they want to take bonding leave or leave for a newborn child, it used to be that they could take a total combined 12 weeks between the two of them. So it'd be 6 weeks apiece or 8 and 4 or what have you. The change that was made was that now both of those parents that work for you are each eligible for 12 weeks. So as you can imagine, for smaller employers with 5, 6, 7 employees, you've gone from maybe losing a person for 6 weeks out of the year and then losing the other person for 6 to losing both people for 12 weeks out of the year. So pretty drastic change, and obviously something to plan for, something to talk to your employees about. So let's talk about those covered reasons for CFRA or for taking the California Family Rights Act leave. We have baby bonding for the birth, adoption, or foster care placement of a child. The employee's own serious health condition. So in other words, they're ill, and this could run concurrently with, say, a workers' comp leave or things like that, right? As long as you're notifying the employee that yes, your CFRA leave is going to run concurrently with your workers' comp leave. However, and this is where CFRA differs from possibly FMLA, is that the California Family Rights Act 12 weeks leave cannot be taken concurrently with a pregnancy and disability leave. They cannot run at the same time. So just as a refresher, pregnancy disability leave provides eligible employees with 4 months of leave. Documented leave as long as their medical care provider determines that they need that time off, that they're disabled for that time. So once the clock stops for that pregnancy disability, you cannot start the clock for the California Family Rights Act. It has to run separately from that. So technically, you could have an employee that's out for 4 months and then an additional 12 weeks after that for CFRA or bonding leave. That's one of those exceptions we talked about where it cannot run concurrently with that. You can take CFRA leave if you have family in the armed forces. So that's the military exigency leave. In other words, if you have a family member in active duty and you have to take time off, either to help deal with some of the matters there, care for family, that sort of thing, that could be covered. And finally, for family care, if you're caring for a family member with a serious health condition. Okay. So as I mentioned earlier, under Assembly Bill 1033, we've now added parent-in-law as a covered family member. So it's not just child or immediate family. Now you have your mother-in-law, your father-in-law. If you have to care for them, you can take time away for that. Something else, we mentioned the small employers as of January 1st, 2021, fell under the CFRA's umbrella. So it's troublesome for some employers, right? I mean, especially if you have a smaller workforce, now you have a protected leave. Something the state is offering that could be beneficial to smaller employers, though, especially if you have a complaint regarding a CFRA violation, say an employee says, you violated or you interfered with my leave. The Department of Fair Employment and Housing now has a pilot program for mediation, so that if there's a complaint, it doesn't immediately go into right to sue letter or anything like that. Now the state offers some help, so to help resolve that issue before it becomes a bigger matter. So if you're one of those small employers with between 5 and 19 employees and there is an issue with CFRA, one of your employees is alleging that you interfered with it, that you didn't follow the law, that you violated their rights, make sure you contact the Department of Fair Employment and Housing about their mediation program, because it could be very helpful and it can avoid a lot of other larger problems from developing. So now our checklist about what employers should do for 2022 as far as CFRA goes. I touched on a couple times that CFRA is its own policy, its own program. So make sure you're updating that CFRA policy to include parent-in-law as a covered family member, right? And not just that, but I mean, the policy, the forms, you have to do some updating as far as that goes to make sure that, all the information on there is correct and everybody is receiving the right information and knows what their rights are. And as always, update those posters. Whenever there's a change, make sure you have the most up-to-date poster up there. A lot of our members or other people order posters from us, from a lot of other locations on a yearly basis. So it's time for a new one, right? It's January, it's that time of year. So speaking of posters, I mean, it's almost the rite of winter, right? Once December rolls around, November, sometimes we start thinking about updating our posters for the following year. Hopefully everybody's got their new ones ordered, updated, received, and up in your lunchroom or your break rooms or what have you. So, make sure that that's up to date. Now, one interesting law that came to pass was SB 657, which allows employers to provide posters required in the labor code electronically, right? So, which is it could be a good thing in that case, because a lot of employers that have remote employees thought, oh well, maybe I can now send send all my posters electronically. I don't have to send that big poster to my remote working employees. Well, unfortunately, that's not quite the case just yet, and it could be a case in the future, but it is not yet, because there's still specific posters, certain posters that cannot be sent electronically. So, if you heard about this law and you thought, hey, it's okay to send everything electronically, we're not quite there yet, right? So if you are going to send something electronically, make sure you know which are the ones that you can send and which ones you have to provide physically. We still recommend that if you have remote employees, just send one of those all-in-one posters. I know it could be it could be a hassle sometimes. I mean, it's an extra expense. You wonder where they're going to hang it up, and if they're working from home, if it's going to be sent in the kitchen or something. But just make sure you're sending that poster, that all-in-one poster, for the time being. Once this law expands a little bit, maybe, or provides more coverage, maybe we could do all electronically, but we are not quite there yet. When it comes to record retention, SB 807 expanded record retention requirements for certain employer documents from 2 years to 4 years. So, for the most part, human resources professionals are leery about getting rid of old employee files, documents, that sort of thing. So just make sure that if you were one of those people that were just always waiting on the clock to see when you could shred or get rid of things, that requirement for retention has expanded to 4 years. So this includes things like applications, personnel memberships, employee referral records, things like that. It is a 4-year retention requirement now. And something to keep in mind too, though, is if there is legal action taking place involving any of those files, you should not get rid of those until any investigation or any civil action has closed. So in other words, if you have an employee file and you're at the 3-year and 10-month mark, and since you've had it since the employee left, and you're looking to get rid of it, but then there's a complaint filed against you, you can't get rid of that file at the 4-year mark and just say, oh well, we hit 4 years, I don't have it. If there's an active complaint on it, you have to hold on to it until that investigation or that civil action is closed. And if you think about it, really, I mean, for the most part, it is to your advantage to have that on hand if there is a civil action or any kind of legal action going on, because that documentation is going to be your best defense when it comes to dealing with any issue. So, just keep in mind, if you're the type of person that likes to shred things or throw things out 2 years after an employee left, in many cases, you have to hold on to that for 2 additional years, now for a total of 4 years. So just make sure you're holding on to it just a little bit longer. Now I mentioned CalSavers, and this basically is going to have an effect on smaller employers now. This CalSavers, for those that have heard of it, is basically almost like a state-run pension program or a state-run retirement savings program for private sector employees who don't offer a retirement program. So if you're a company, whether you're large or small, and you don't offer any kind of pension or 401k program, CalSavers is for you. So now, once again, the magic number is 5, and as you can see from a few of the past slides, the state of California really likes the number 5. That's going to be our cutoff for a lot of things, and CalSavers is no different. So if you have at least 5 employees and you don't offer a qualified workplace retirement plan, such as a 401k or things like that, you have to register with CalSavers by June 30th, 2022. So June 30th is your deadline. You know, if you're one of these small employers and you have your planner handy, put a note on your calendar, put a star, put something on there by June 30th, but make sure that you're registered by then. And from what we understand, the registration process is not very cumbersome. And basically it's sending a payroll list with your employee information, such as, you know, name, social security, birth dates, and contact informations for all eligible employees into CalSavers. And from then, they're the ones that send out the investment information and that sort of thing to them, defining different programs and what CalSavers can do for them. You know, we've been told it takes anywhere from 30 to 15 minutes or 30 minutes, I'm sorry, to complete the process. And, you know, once you send it in, just kind of make sure that all employees receive the packet with information from CalSavers. You know, as long as you're providing CalSavers with that contact information for your employees, that information is up to date, that portion is pretty much out of your hands because it's up to the state to send out that information. Now, unfortunately, you know, that's not the end of the responsibility for employers. If an employee decides to participate in CalSavers, you know, you're going to have to do the deductions out of their payroll every week. You're going to have to send it in the CalSavers whether on a regular basis. So it's not, you know, it's not something where you just sign them up and then it's completely out of your hands. You're going to have to manage a part of it, unfortunately. So, but just keep in mind, you know, that magic number is 5. If you have 5 employees or more, you got to be registered as a small employer by June 30th, 2022. So, list of employer obligations. You know what you should do if you're an employer that falls under this CalSavers umbrella. Make sure you register by the June 30th deadline. So, put a big, you know, red X, write CalSavers, whatever you need, but make sure you hit that deadline. You do that by setting up that payroll list and sending it in. Make sure employees receive those CalSavers packets, right? Let them know, you know, that you sent the information in. They should be receiving something. Just, you know, make sure you touch base with them. Make sure that they are receiving the right information. If an employee participates and wants to make deductions from your paycheck, you're going to be managing that and you're going to be sending that in. So, you know, make sure, as I said, you know, I mentioned the external payroll provider a lot. If you have one of those payroll providers you're working with, make sure you let them know that you have some deductions coming up. You're participating in CalSavers. They should be able to set that up with you. If you do everything in-house, you know, start working on that process or that procedure for doing so. And of course, ongoing maintenance, right? Maybe you have an employee that wants to contribute, you know, $50 this month and $100 next month and $1 the following month. You know, that's going to be up to you to make those adjustments into the payroll system to make sure that the right, you know, the right information or the right dollar amounts coming out, and that you're updating their address and other things like that so they receive all the right information from the state. So as a side note, kind of goes along with CalSavers, 401k contribution limits did increase this year by $1,000 up to $20,500. So if you have employees that like to max out their 401k contributions for the year, you know, make sure you let them know so that they make those adjustments to their contributions. So takeaways from policies, practices, and records for employers. Make sure you update that CFR 8 policy and forms. You know, we mentioned that the changes are substantial enough to where CFR 8 is its own program, should be its own policy, and has its own forms and policies and procedures. Make sure managers are trained on protected leaves and proper record retention. I mentioned earlier, your managers, your supervisors, the first line, they're your first line of defense against any issues, right? So make sure that they know their responsibilities for protected leaves. You know, this includes paid sick leave. Paid sick leave has been with us for quite a few years now, but there's still some violations that take place. So make sure they know what they can and what they should not do when there is a protected leave in place. Okay. Are your posters up to date? Said, you know, every November, December, everybody should be ordering their new posters. Now, if for some reason you ordered your poster last year, but you have not received it, as long as you have that receipt, you are still compliant. There was a delay sending a lot of posters out because some of the forms from the state were actually not completed by the time the new year rolled over. Many companies are waiting for the state to complete the new forms, you know, make their changes before printing up the poster. So as long as you have that receipt that you ordered it before the new year, you are compliant in case there's an inspection or somebody comes along. Now, that's only goes so far, right? I mean, you can't have OSHA or another agency come into your place of business in June or July and you don't have your poster up and say, well, I have my receipt. I mean, that little common sense comes into play there. This will cover you for a couple of weeks while the posters get there, but once the posters send out, it's up to you to make sure that they are up, posted, and with the correct information. Okay, small employers, get ready for the CalSavers deadline. June 30th. I mentioned that that's about the 10th time I've set that date now, I think. So make sure that you're aware of that deadline and that you are updating everything, getting your files, your records ready to send in to CalSavers so that your employees can participate in that program. So with that, that brings us to the end of the first section. I will transfer it over to Astrid, who's going to cover safety and COVID-19 updates, which is everybody's favorite topic for the past 2.5 years, I believe.
Yeah, I don't know about favorite, but definitely on our minds, and it doesn't seem to want to go away. So we're going to do our best we can to cover what the latest and greatest is in the COVID world here. Just bear with me for a second there. Am I okay there, Eli? All right, wonderful. Well, thanks for that first section, Eli. That was very informative. Lots of new changes especially for small employers. I think that CalSavers one kind of sneaked up on us because we kept ignoring it. And then suddenly here we are faced with it. So thank you for that information. We'll move on to COVID. As you know, the beginning of the year has been faced with many agencies weighing in on their opinion on what the guidelines should be. And I think after 19 days in the beginning of the year, we're somewhat aligned. And I say somewhat, so we'll go through kind of where we are here. Lots of phone calls in from your county, from many counties throughout the state, wondering what we should follow, what we should be doing. And so we've stayed on top of it. And as recent as Friday night, like 7:30 p.m. is when CalOSHA likes to send out their alerts. Some updates were sent over to us. And so we're going to go through those today and do the best we can. If you have any questions, please put them in our Q&A, and Eli and I will do our best to answer them. So here's a frequently asked question we get asked a lot into our hotline. We drafted our injury illness prevention plan a number of years ago. I'm not sure when we last updated our handbook even. Does it really matter? And of course, the answer is yes, because they're written policies. Whatever you put in writing matters. It can hurt you or it can help you. So these words definitely matter. If you end up in a lawsuit, it may be used against you. If you end up in a lawsuit, you may be able to use it to support your case. So these documents are going to assist you as the employer to communicate what your policies, how do we do things to your employees. The injury, illness, and prevention plan is your safety handbook, if you will. And then the handbook is going to be all the other policies that we include that typically are not safety related. We do have some workers' comp and safety issues in general. But just remember, if you're an employer with 10 or more employees, you are required to have a written, what we call IIPP, Injury Illness Prevention Plan. So give us a call if this is news to you and you're unsure what that even is, and we'll get you started with that information. So as you know, the legislator was very busy passing many safety bills, and these were all aimed because of COVID-19 or very much motivated by COVID-19 and the pandemic. So here's our first one, and this is CalOSHA's authority has changed, and it's given them a little bit more authority with SB 606. So SB 606 creates a rebuttable presumption that a violation by an employer that has multiple work sites, so if you have multiple work sites, that violation is enterprise-wide. Enterprise-wide meaning it's happening in all locations. If it happens in one, then it must be happening in all locations. And this is true in two circumstances. If the employer has a written policy or procedure that violates the law, such as not having an updated COVID-19. In fact, I got a call this morning from someone who had a policy that was written aimed at trying to, minimize these COVID issues in the workplace and communicate what it is they do, but they were following OSHA standards, not CalOSHA standards. And so that was incorrect information. Someone pointed it out, so they sent it to us for help because they were saying, we thought we were doing the right thing. And there's something to say that an employer is doing things in good faith. But if you're a California employer, you really need to be up to date with CalOSHA. Keep things in federal OSHA, of course, in mind, especially if you have federal contractors and that kind of thing. But always keep CalOSHA front and center as well. The other time and the other circumstance that SB 606 will apply is if Cal OSHA has evidence of a pattern or practice of the same violation involving more than one work site. So what this means is if you have one bad apple in one work site, then it must be true and presumed for all other work sites. And this is, you just really got to be careful because the burden will be on you as the employer to prove otherwise. So ensure that your policies are up to date and that you're including information, that the correct information that you should have. Cal OSHA has updated their plans, so you want to make sure you have the latest version, and we'll talk a little bit more about that in a future slide. But just remember that an enterprise-wide violation is subject to willful or repeated conduct penalties that are very steep. They can be as high as $134,000 per violation. And then SB 606 also creates a new definition and penalty for an egregious violation. So when an egregious violation includes when an employer intentionally made no reasonable effort to eliminate a known violation. And there's 7 different ways an employer could be acting in bad faith. And if an employer is not reasonably making an effort to try to eliminate that hazard, then the penalties are very high and can be far reaching because it's going to be per employee. A violation is going to be fined per employee. So they can really add up quickly. This Senate bill was designed to kind of crack down on those health and safety issues in the workplace, and it's giving Cal OSHA greater authority to deal with those issues. So we need to be aware of it. And this is not just COVID, it's all safety issues in the workplace. So what should you do as an employer? You know, if you're in a small, low hazard industry, you're not going to be required to do a whole lot, but you're going to want a safety expert to review those policies and ensure that you're up to date with the latest. If you're in a high hazard industry, you're going to want to work with counsel and a safety expert to review your practices and ensure that everything is up to date and that you're following what you say you're following in those plans. So update your injury illness prevention plan. Take a look at it. Some people haven't seen it for years, and it should be an active working file, something that you have. And then, of course, update that COVID-19 prevention plan. Just as late as this beginning of this year, there's been some updates to that COVID-19 prevention plan, which is what we're going to talk about next. Remember that COVID prevention plan is for all employers, no matter what number size employees you have. If you have on-site workers, then this will apply. Everyone working remote, you're fine. But at the minute you have one on-site worker, then you need a prevention plan, because this is what the motivation of this is to prevent and to minimize and to what is it that we're going to do when we have a COVID-19 exposure or positive case. This law, this CPP, went into effect in November of 2020, way back when, and the template was just updated last in June of 2021. So you should have this latest version. You can access that through our website, through employers.org. You go to the COVID-19 resources, which are all free to employers. And there you'll find the link to the COVID prevention plan. So it's a template, it's a Word template. You're obligated to implement and maintain this written plan. There's 11 separate requirements. You kind of go through there, and most of it is written for you. You just have to fill in the blanks, fill in your specific information for your work site. The update that came just recently is that you have to allow adequate time for hand washing and cleaning frequently touched surfaces and objects. Make sure that's highlighted in your CPP. It was always in there, but Cal OSHA has recently, again, Friday, made that clarification. They really want you to allow that. So some employers are putting in a policy in addition to this, where they're reminding employees or putting it in the break room to frequently hand wash and then clean those commonly touched surfaces. You also have to train your employees on the CPP. So you need to make sure you're allotting time to review this. If you have new hires, ensure they know that you have a CPP, and ensure that you are going through kind of what the policy and procedures are should they be exposed or have a positive case. This can be a part of your IIPP, that injury illness prevention plan, or a separate document. We recommend to keep it separate. Should Cal OSHA come in and request to see your COVID prevention plan, you wouldn't have to hand over your whole IIPP, you would just hand over the CPP. So just make sure you have that. If you have, it's probably the area that employers are getting fined with right now from Cal OSHA, and it's an easy fix. Just having it available and ready is going to get you your fine. You're not going to have a fine for that. So make sure you at least do that if you have on-site workers. Okay, so there's been some standards updates. As you may remember, the emergency temporary standard is what we call the ETS. Cal OSHA has readopted this with some amendments, and that's what all the buzz was about in the beginning of the year. And that's going to be effective as of last Friday, January 14th, all the way through April 14th. At that time, that ETS is probably going to be either extended or I think Cal OSHA is working on something more permanent to have. So we'll see what happens with that, but at the very minimum, expect an extension of the ETS. So as just some little history on this, following the CDC changes we saw in December, end of December, the California Department of Health, who is our guidance in California, updated its isolation and quarantine guidelines, and it was very similar to what the CDC recommended. And then on January 6th, Cal OSHA clarified in their FAQs that those exclusion periods with return to work, which we're going to review next, they should align with the California Department of Health for workers. The CDPH, remember, they're the health department. They're recommending guidance for all the community at large. The Cal OSHA is there for workers. So they are saying we want to align for our workers. And then again, just as recently as January 14th, Cal OSHA did provide some fact sheets, and once again updated the FAQs, which includes the hand washing requirement and training employees. So make sure that you kind of review those. I'm going to put a link to the Cal OSHA area where you can find some of this information so that you have it available. The executive order was put in back in 2020 by the governor, and that executive order stated that anytime CDPH updates their guidelines for exclusion periods or for any COVID-related items, then Cal OSHA would follow and would align. So that's kind of where we're getting that guidance from. We had many calls into this, and we refer to our COVID exposure toolkit. So CEA has what we call a COVID exposure toolkit. It goes line by line, depending on your circumstance, whether it's an exposure or a positive case, what your obligations are as an employer. I know I refer to it, probably Eli, you refer to it many times in a day when we're talking through a specific scenario with an employer, because it's going to vary, right, depending on the circumstances. So if you're a member, you have access to this. I know we have some members that are on. If you're not a member, then you can always give us a call and we'll go through that guidance with you. So I'm not going to review all of these in great detail because there is a lot of information. If Eli, maybe you could put in the chat, I think maybe I could even do that, the website to Cal OSHA. And this is, again, if you're a member, we have it all for you. And we actually have it also on our website. There we go. If you go to employers.org and COVID resources, we have a link to that diagram that Cal OSHA provided for us in the FAQs. So these are kind of high level requirements and exclusion rules that I'm going to review with you. Right now, we're under a mask mandate in California through February 14th at least. So this won't apply yet right now because we're currently in that mandate. But when that mandate goes away, then anyone who tests positive or is exposed to COVID-19 must wear a face mask around others for a total of 10 days after a positive test or an exposure, especially in indoor settings. So that's going to continue on with us here, at least through the April 14th date. If somebody tests positive, you're going to exclude them and that's regardless of vaccination status. If they're testing positive, you exclude for 5 days. They can come back after day 5 if the test is negative on day 5 or later, and the symptoms are resolving. If you do not test, or if you're unable to get a test, they can come back after 10 days if the symptoms are resolving. Then we have a next category with those, which are those who have been exposed to a COVID positive case and they are unvaccinated. You're going to also exclude them for 5 days, and they can come back same day, same way, after 5 days if they test negative on day 5 or later and they have no symptoms at all. If they cannot take a test, it's going to be the same, 10 days if no symptoms at all. And well, let me skip a step here. Okay, so then we got the next group, which is the exposed vaccinated, but they have no booster. And this is because they're choosing not to get a booster. They haven't gotten around to the booster yet. They do not need to isolate if a negative diagnostic test is obtained within 3 to 5 days after last exposure. They continue to be symptom-free, and they wear a face covering for at least 10 days. So that 3 to 5 days is going to be key in ensuring that they get that test and that it's negative. And then that you will find in the footnotes. A lot of people say, I don't see that. And that was in the original area where you find it is in the footnotes of that section there. They may have clarified that now. If you're exposed, vaccinated, and have received your booster, or you maybe are completely vaccinated and you're not booster eligible yet, these group of people do not need to isolate at all if they are asymptomatic, but must test negative at day 5 and wear a face covering for at least 10 days. So there's, again, high level and refer to the charts that Cal OSHA has provided to ensure that you're following, and those come from the CDPH. So moving on, we'll talk a little bit about face coverings. There's been a few highlights and some clarification from Cal OSHA about face coverings and what's acceptable. I think some people were taking advantage and really not covering up much at all. And in light of this new variant that we're seeing, they're saying this face mask really matters. So light should not be able to pass through the fabric mask, you know, and it depends on what kind of light are you using and all that. So use good judgment, of course. I won't read all these to you, but here are some of the requirements, some of the acceptable language that Cal OSHA has provided for us. And remember that employers must provide acceptable face covering or reimburse employees for this cost. This continues to be the case in California. And for those of you who may have workers in LA, Los Angeles County has a very specific mandate regarding face coverings and employers' requirements for those face coverings. They also have their own unique return to work criteria because the LA County Department of Health. So I'm not going to go into that because this is not LA County, but if you have workers that are working there, just know that there is some more additional information that may apply to you. So with that, kind of transitions over to public health notices, because how are you supposed to know when things change and how to keep up to date with all this? You can always call us because we keep up to date with all these things. But SB 336 was introduced and passed, and this requires California Department of Public Health and local health officers to publish COVID-19 orders or mandatory guidance on the website. Because if you remember in 2020, we were all searching for this and that, and it was hard to find. You click here and then you lost it, and then it changed and the website was gone. And so this SB 336 was really designed to help employers, to help people in general, figure out what is the latest information, what am I supposed to be following. It also required to allow employers and others to sign up for email distribution, so like a listserv, and I know we sign up for these to receive these orders and guidance, and they'll email them out to you. So Cal OSHA is one that will do that, as well as other health and officers and health departments out there. This is just kind of aimed at ensuring employers have easy access and that we're all following the most current rules. So this is a win for employers who we were just really getting frustrated and frazzled about what the latest information is. So check these agency websites where you have workers. You maybe have workers in multiple sites. So you want to make sure that you sign up for these distribution lists. Okay, so a year ago, we were talking about mandating masks for employers, and we thought that was the worst headache we were going to have. And now we're talking about mandating vaccines. I don't know what we're going to be doing a year from today. So, well, before we get started on the CDPH orders, I want to talk about private employers. And as a private employer, you're always going to be allowed to put a mandatory vaccine policy if that's what you wish, that's what you'd like. So long as there's a business necessity and you're consistent with that business necessity and it's job related. So you can make that argument if you have workers on site and we have a pandemic going on, that's a pretty good argument. You do have to make accommodations for those medical reasons or for deeply held religious beliefs. You always have to allow for that, but you can, as a private employer, make that a mandatory policy for everyone to vaccinate. The CDPH, the California Department of Health, does require certain industries to mandate this. Healthcare employers, public and private, are required to mandate the vaccine. This includes getting that booster shot by February 1st or within 15 days of becoming booster eligible. And also requires for workers in adult and senior care facilities and those employed in in-home direct care settings, this mandate applies to them. There is an exception for them for religious and medical reasons. There's also other groups, other industries that are required maybe not to mandate completely the vaccine, or they can mandate the vaccine. And if an employee chooses not to, then they need to undergo weekly COVID-19 tested if they're not fully vaccinated. So this would include dental offices, school personnel, and most state workers. So really cracking down on trying to get people vaccinated the best they can. We know that Biden tried to do this with the Osha ETS with 100 or more employees. And as we've heard on the news, this has been blocked by the Supreme Court. But very quickly, the Osha ETS was for private employers with 100 or more employees, corporate wide. And this would require them to establish a policy mandating the vaccination or requiring unvaccinated employees to do that weekly testing and wear face coverings, among other requirements. So the United States Supreme Court heard those oral arguments, and it was in appeals courts and all that, and now they have ruled that they blocked it. Actually, they haven't ruled completely. That final decision hasn't come down yet, but we are expected to see that in the coming weeks or days. It'll become final. There are some things from there that may continue to try and pass, so maybe they're going to break it down, and so it's not completely final where we should just not disregard this completely. It should still be on our minds because some of this stuff may pass yet. But the way it's written now, it is not likely to keep going. However, there is some industries like the healthcare workers, some of those things were upheld in the federal courts. If you're a federal contractor, if you deal with federal contractors or subcontractors, there is some litigation pending, so you should consult with your legal counsel. So there's a few things that did carve-outs that did pass, very minimal, but if you are in the healthcare industry or if you're dealing with federal contractors or subcontractors, get some legal counsel to assist you with those requirements and implementing those. Okay, so a little bit more, we're almost done with COVID. This is our last slide. So this is all related to COVID, some expiring rules. The I-9 remote inspection. So this is if you have remote workers and you're not on site yet. And so you're able to review those I-9 documentations virtually, not in person. You cannot inspect those in person. That has been extended to April 30th. We expect that to continue. They've extended this many, many times, this deadline. And so long as you have remote workers, this will probably continue to apply at the very minimum through April 30th. Remember, as soon as you have one remote worker that comes back to the workplace, this rule, this flexibility goes away, and you're obligated then to check those remote worker I-9s that you may have missed since you've been remote. This also does not apply if everyone's back and you're good to go. So this worker notification of COVID exposure, this other one, this is when you notify workers of COVID-19 exposure in the workplace. This has been extended to January 1st, 2023. I expect that to it seemed like such a long time ago last year when they first implemented this, but we're less than a year away now. And so if COVID still continues, I imagine this will be extended. That workers' comp consumption as well, that is through January 1st, 2023. We'll see if legislators extend that as well. Okay, we're done with the COVID world here. No more COVID talk, at least not for now. We're going to continue on with some industry specific laws that have been introduced that may not relate to your industry, but we should keep an eye on them because if we see it happening in one industry, it's likely to continue on. Legislators like to test something out or introduce it in one industry and then expand it to other industries. So we'll keep an eye on some of these unique things that are happening out here. So the first one is the warehouse distribution at AB 701. It's a law targeted at companies like Amazon, big warehouse companies, which have come under scrutiny lately for harsh working conditions. This is for covered employers with 100 or more employees at a single warehouse or 1,000 or more employees at one or more warehouse distribution centers in California. So this must provide each non-exempt or hourly employee upon hire with a written description of their quota. And each quota includes quantified numbers of tasks, materials, what they're supposed to do within what defined number of time. And also needs to list any potential adverse action that may result from failing to meet the quota. They want it in writing, what the quota is, what is the adverse action for not meeting it. They want to make sure it's reasonable. And then that quota must not prevent compliance with all their rights for meal, rest, recovery, bathroom, and especially health and safety. So they really want it in writing. It kind of puts a spotlight on quota, whether or not it's reasonable or not, and whether or not employees, informing employees of their rights, and what they can do and what they're required, what they're being asked to do, and that they know that they can still have their rights to meals and to breaks and to recovery, all that good stuff. So it provides clarity to both sides here about their rights in the workplace. And it also provides employees to kind of be able to sue these companies a little easier for violation of PAGA. It makes it easier for employees to sue. There's also a clause regarding retaliation as well for not following this. So they're really this is aimed to kind of crack down on these sneaky tactics. And we can see this maybe happening in other industries, definitely, where quotas are being set at an unreasonable rate and where employees feel like they can't even take a bathroom break in order to meet that quota. So this is really for the warehouse industry and the distribution centers, but I expect to see this again in other industries. This next one is also specific to the garment industry. It's very similar to SB 62, to the previous Senate bill with warehouses, but this is eliminating piece rate altogether. And it's funny because I just got a call about piece rate this morning. So there's other industries that do piece rate. The garment industry is one of them, and it's considered a legal form of payment for employees. However, this is eliminating that for the garment industry for these non-unionized workers. So this imposes a statutory damage of $200 per employee per pay period in which an employee is paid by piece rate. And it expands joint and several liability of wage violations for the entire garment manufacturing supply chain. So big changes for them. This is how they've always been paid. So this is a big change for this industry. Piece rate, for those of you who may not know, is when someone is paid by the task or by the number of materials, we say widgets, that they make. It's a way to kind of incentivize production. But this is a way to, again, eliminate this type of payment. Again, some harsh conditions here in certain industries. And so big fines for not following through. So takeaway is that the piece rate may be on the chopping block for future industries that may be using this as a type of pay. Maybe start thinking about eliminating that from your pay practice if this is the way you pay. So here's another frequently asked question that we get asked a lot is, especially recently, especially beginning of the year. I downloaded a settlement agreement I found on the internet and edited accordingly. Is this okay? And you should know if you're downloading something from the internet. The answer is no, because there are many pitfalls to doing this. There's very specific language that's required to release legal claims. There is other language required depending on the person's protected status, for example. And so there's a lot of legal lingo that goes into a settlement agreement, and a lot of this has changed. So very recently. So when, for example, when non-disparagement provisions are involved, the employer must exclude employee's ability to discuss conduct the employee believes was unlawful. If they in good faith are discussing things they believe is unlawful, then that would be a violation. So we can't prevent that from being included in a settlement agreement. It also extends the prohibition on confidentiality provisions in settlement agreements to all discrimination. It used to be, the Me Too movement really pushed this for sex discrimination and harassment, but this is all extending it to all discrimination, not just sex. Remember, the employer can require a settlement amount to be kept confidential, and we want to do that. We don't want to throw our cards out and know and disclose how much we're willing to pay as a company to employees. But we want to make sure that at least that we can keep confidential, the amount of settlement money. But other things may be, you may be unable to do that. So some settlement agreements, do's and don'ts. Work with legal counsel for sure. We don't do settlement agreements at CEA because we're not your legal counsel. And that is something that is very specific to you as a company. So definitely work with an attorney to ensure that you're compliant with the latest information, that you're not putting things you shouldn't be putting in there. Now, however, do not alter previous agreements without speaking to legal counsel. This law is not retroactive. So if you had that information about confidentiality and all that in your previous settlement agreements, you're likely to be okay. This is just moving forward beginning this year. Okay, so some final reminders here. We're at the end of our labor law update. We appreciate you attending. Some things to do. We want you to continue to attend some upcoming labor law updates. As you can see, things change very rapidly, especially in the safety world. So we do this again in mid-year. I think we have those trainings, webinar signups, registrations open already. So we do this mid-year labor law update. We'll see what's going on in June, July regarding COVID. We also want to remind you to update your handbook. As Eli mentioned at the beginning of this presentation, lots of policies have changed. You need to update some mandatory things there. 2022 updates for CEA members are available now. We have them on our website. So if you're a member and have our handbook through us, then you can update those employee handbook updates are available every year in January. So we provide those to everyone on an ongoing basis. So if you do not have a handbook, I encourage you to visit us to see what your options are. We have very good competitive pricing there for handbooks. We also provide harassment prevention training. If you don't get it through us, get it through someone that is California compliant. You want to make sure that it's California compliant. This is due every 2 years. So we want to remind everyone, because of COVID, we kind of tend to forget things like harassment prevention because we put it on the back burner. But if you trained your employees back in 2020, this is your training year, 2022. So various different ways to get that training. You can do it through a live webinar like this one. You can do it through a personalized webinar for all your staff. You can do it online version, which is free to members. So definitely check out how you can get it, but just ensure that it's a California compliant harassment prevention training, because that you need that in order to count. So some things to kind of watch out for. Of course, Osha, the ETS, around April, we should know probably before then whether they're going to extend that ETS or make a more permanent law regarding COVID and the effects it has on our employers here with Osha. We've been seeing in our crystal ball here this paid sick leave increase, which is AB 995. Right now, the state paid sick leave is 3 days in a year. They're looking to increase that to 5 days, so look out for that. Some local, of course, local ordinances have more than that, but statewide, we're looking at an increase to 5. AB 95 is looking at a required mandatory bereavement leave. As you know, private employers do not have a requirement to provide bereavement leave. Many companies do, but that is not required. So they're looking to include that, an actual requirement. I think it's like 3 days for small employers and 5 days for large employers. They're also looking to have a designated person for that California Family Rights Act leave. That's AB 1041. In the part, I think San Francisco already has this, where you can designate a person as an eligible person to qualify in the case of California Family Rights Act. So you can designate a friend, a neighbor, a distant cousin, a teacher, whoever, to be your designated person in case of a CFRA. So that's coming. None of this stuff on the right is true yet, but it's things to look out for in the coming months and years. All right, so that is all we have for you today. We appreciate your attention. We have some HRCI and SHRM codes for those of you who are participating in extended education here in the HR professionals. So I'm going to leave these up for a little bit, and I'm just going to see if there's any other questions that we might have. Eli, anything else that you'd like to add, or anything else? Otherwise, I'll turn it back to Tara.
No questions in the queue. We did add a few links for some COVID resources, some of our upcoming events. Tara added in the Alameda County Workforce Development Board's hotline, so give us a call. We'd love to hear from you.
Absolutely. Thank you. So thank you for your time, Tara. I'll turn it back to you, I believe.
Awesome. Thank you guys so much. Yes, I appreciate that. Again, the codes were just up. I didn't grab those to put them in the chat, but I did put the 800 number in. Also, don't forget that this webinar was recorded and it will be on the Alameda Workforce Development's website. And there is going to be a quick survey, so if you wouldn't mind taking that. And then Carmelo, I believe, are you still here? I think there he is. Great.
No.
Turn this over to you and say thank you so much for having us. We really do appreciate our partnership with the Alameda County Workforce Development Board.
Well, thank you, but Carmelo had to leave for a minute, and I just want to thank each and every one of you, and also those of you that attended today. Just a little reminder that April, we're having the recruiting in COVID, and in July we have leave laws, and also in October exclusively in the workplace. And I really hope to see each and every one of you. I think this is great, and we will be sending out flyers for a reminder to the employers out in Alameda County. Thank you.
Bye, everybody. Take care. Be safe.
Thank you.